A federal appeals court ruled that Donald Trump cannot claim presidential immunity for his alleged election interference. What does that mean? Let's talk about it. As we know, Donald Trump is currently facing federal election interference charges at both the state level in Georgia and the federal level. This case we are talking about in this video deals with the federal case. So when special counsel Jack Smith brought this case, one of the defenses that Donald Trump put forth was presidential immunity. In other words, the actions that he took stemmed from his official duties as president, and therefore under Article 2, Section 3, he had presidential immunity and could not be prosecuted. This defense was first presented to the district court judge, who ruled against Donald Trump, finding that setting this sort of precedent would basically give a license to presidents to carry out whatever criminal activities that they desired. Trump appeals this ruling to the appellate court. Meanwhile, special counsel Jack Smith takes this to the Supreme Court, and he requests the Supreme Court's intervention before the appellate court. The fact of the matter is that Jack Smith wants to speed up this case to have the trial take place before the election. Donald Trump wants to delay this case. Because of this, Donald Trump asked the Supreme Court not to get involved, and the Supreme Court didn't. They say you need to take this to the appellate court first, then you can come back to us. And that is the ruling that we just got on Tuesday. The appellate court ruled against Donald Trump in finding that he is not entitled to presidential immunity for the alleged election interference. Specifically, the appellate court said in their unanimous decision that Donald Trump injected himself into a process in which the president has no role, that being the counting and certifying of electoral votes. The court also said it would be a striking paradox if the president, the one who is vested with a constitutional duty to ensure that the laws are faithfully executed, were the sole officer capable of defying those laws with impunity. The court said, "We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter." Now, the appellate court gave Donald Trump until February 12th to appeal this ruling to the Supreme Court of the United States, which he will do. Meanwhile, on Friday, the district court judge did officially postpone the March 4th trial date and did not reschedule to give the appeals time to play out. So from here, the Supreme Court can either agree to hear this case, or they can leave the decision with the appellate court and let that ruling stand. For more unbiased news, check out the Unbiased podcast, available on all podcast platforms and on video on YouTube and X.